Hello and welcome to this AIDWA Live. So as we know, yesterday on 12th March, AIDWA completed 40 years of its existence, and in this time, the organization has led various legal struggles, legal interventions for the rights of women. And so, on this occasion, we have with us Supreme Court Advocate Kirti Singh, who will be talking about these struggles, about the legacy of AIDWA, and also what struggles now need to be led in the future and what struggles, what fights women are fighting for today. Thank you, Comrade Kirti, for joining us, and please, you may take over.
Yes. Well, I was going to speak on continuing the battle for equal rights for women today. Since to talk of AIDWA struggles for change of laws and campaigns for change of law is something that will have to be talked in length about each separate law that we have brought about. And I think that will be the subject of several discussions. So I won't pretend to do that today, except to refer to some of the major laws that we have changed over the years. And then to talk about the struggle that we are carrying on today. During the BJP NDA regime, we have been passing through a dark phase in our history for women's rights. We have seen regressive laws and regressive amendments in the laws being passed. No reforms for eliminating discrimination or promoting equal rights for women or for ensuring the dignity and autonomy of women have been passed. This has meant that the absence of law in certain critical areas, like crimes and killings in the name of honor, like a law giving equal rights to women in marital property, and not recognizing marital rape has remained. The regressive changes in law have been the introduction of the death penalty in certain cases of child rape and subsequent amendments in POSCO. The central government has also introduced a communal and regressive criminal law against triple talaq. Instead of providing for the safety of young couples involved in choice relationships, BJP-led state governments have introduced laws ostensibly to curb a fictitious love jihad. In fact, this has meant a direct interference with and criminalization of relationship by choice and with the freedom of conversion. There has been a strengthening of patriarchal and feudal mindset within an increasingly authoritarian Hindutva regime. This regime believes in the fundamentalist tenets of Manusmriti and the secondary position of women. The Manusmriti wrote about the need to maintain control over women's body. And Manu is reported to have famously said that women must never be independent. As a child, she must remain under her father's control, as a woman, her husband's, and when her husband is dead, her son's. Manu also implied that women have to be guarded against their inherently promiscuous nature. Manu believed in a rigid caste hierarchy within the society. Muslims and others communities were denigrated as invaders, which, along with other elements of the Hindu ideology, highlights the reason for hatred towards the Muslims and other minority and marginalized sections like SCs and ST. What is clear is the BJP was not and never has been interested in the rights of women. Cases of violence against women, particularly rape, have not only been increasing during this regime, but several prominent cases like the Unnao case and the Hathras case from UP have shown us how upper caste, Thakur men, and those in position of powers like the MLA in the Unnao case have acted with impunity, and how the administration and the entire criminal justice system has supported them. In the Kathua rape and murder case, where an 8-year-old girl belonging to the nomadic Bakharwal community was locked in a temple, drugged, gang raped for several days, after which she was bludgeoned to death, the Hindu Ekta Manth and two ministers of the BJP supporting the accused. In fact, the Kathua MLA Rajiv Jasrotia, who had taken part in the rally, was later made a minister in the J&K government. Several prominent supporters of the BJP have also made misogynist comments and supported those who have committed rape. AIDWA has a rich history of struggle for women's rights, and from the late 70s has been involved in activism at the individual and mass level. It has its legal cell, for instance, started dealing with issues and cases of dowry, rape, domestic violence, amongst others, from the late 70s onwards, and dealt mostly with women from Jhuggis and resettlement colonies in Delhi. These legal cells all over the countries have been steadily working, increasing, uh, with cases involving all sorts of issues concerning women. AIDWA has also been in the forefront, for instance, in campaigns for change and reforms of several laws. The campaign against dowry resulted in its demanding an overhaul of the dowry laws and the introduction of a new law in the Indian Penal Code, Section 498, along with a special species of murder known as dowry debt. When the campaign started, the 1961 Dowry Act was so ineffective and full of loopholes that only 2 complaints had been filed under it for more than 10 years. AIDWA was conscious that law alone could not be effective in curbing dowry, but thought that the structure of law should be changed to allow the people file complaints against under it and to retrieve their dowry whenever possible, and to take action against those who had been violent. Some of the defects in the act were that the act defined dowry as property given in consideration of marriage, and it therefore had to be proved that the dowry had been given as a motive or reason or reward for the marriage. All presents were excluded from the definition, and anything given prior to or after the marriage was also excluded. No direct complaints could be made under this law, and the offense was non-cognizable and bailable. A joint select committee of parliament was set up, and AIDWA participated and gave evidence before it. As part of the Dahej Virodhi Manch, AIDWA lobbied for the law both inside and outside the parliament, with the active support of women MPs like Geeta Mukherjee, Sushila Gopalan, and Pramila Dandavate, who were a part of the women's movement. The select committee reported that dowry had spread all over the country across castes and communities. The 1983 and 86 amendments brought about as a result of the campaign by the women's movement considerably improved the criminal law, except in certain areas. Dowry was defined as property given in connection with the marriage at any time, before or after the marriage. Minimum and maximum punishments were prescribed. The line between what amounted to dowry and what were presents, however, remained blurred. The Joint Select Committee had made many recommendations and had also suggested a restriction on marriage expenses, which was disregarded. Some of the positive amendments of the 1983 law was that the burden of proving that he had not committed any offense was put on the offender. This was a legal recognition of the fact that it was extremely difficult to prove the giving and taking a dowry. The offense was made cognizable and non-bailable. Dowry was made inheritable by women's children, and in their absence by her parents, and her husband was excluded from the inheritance if the woman had died within 7 years of the marriage. Apart from other changes, uh, apart from this, other changes were made. Section 498A was introduced. Um, Dowry death was introduced. Abetment to suicide was introduced in the law. And the introduction of dowry death was very important because hitherto it had been very difficult to prove that uh, a murder had taken place, whereas dowry death specified that if a woman had died and just before her marriage she had been treated with cruelty, then there was a presumption that could be raised, which could of course be disproved. The introduction of Section 498 was extremely important because further as later years showed, the number of cases which were filed under 498A showed that there was a real need to make this criminal law which punished gross cruelty, either physical or mental, with 3 years of imprisonment. However, at present, we face a onslaught by the courts and others, which have time and again blamed women for filing false cases. And AIDWA has been fighting these cases in the Supreme Court. The Supreme Court, for instance, a case in 1917 in Rajesh Sharma's case, said that set up family or welfare committees, which they said were necessary, as they implied that women always lied when they filed cases under 498A. They also said that on the spur of the moment, women file cases, and then went on to say that the lack of convictions under 498 is directly attributable to the fact that women are not filing cases which are true. In fact, the women's groups pointed out, including AIDWA, that this was totally untrue because women didn't file these cases on a spur of the moment. They only filed these cases when it became absolutely necessary to do so, that the lack of convictions was only because of police inefficiency in dealing with the cases, and because many cases got settled along the way, because women found it hard to launch on long legal battles. And in fact, the percentages showed that most of the cases that were filed were prima facie true, because only 7 to 8% of the cases was found to be on account of mistake by law or fact. The Supreme Court had also said in this case that the police should only act in cases in which tangible physical injuries and death take place. And women's groups pointed out that this was totally wrong, as mental torture and abuse and infliction of physical violence, which may not be evident, had not been considered. And that the 498 expressly covers both mental and physical violence. Apart from this, the Supreme Court had given directions that the district legal services authority in every district would constitute a family welfare committee. And in the first instance, any case under 498A would go to this committee. The women's groups pointed out that this was a committee which was completely extrajudicial and was not competent to either investigate a case or find out the truth. So After this, in another matter, AIDWA intervened. And in that particular matter in the Supreme Court, while the family judicial committees, family welfare committees were set aside and said that the law must proceed according to the normal processes of criminal law. However, the court did not set aside several other observations that had been made in Rajesh Sharma's case, and prior to that, in another Arnesh Kumar's case, which had also proceeded on the basis that women were using Section 498 as a weapon. So there have been several efforts to dilute the law, and AIDWA has been throughout trying to fight against these efforts and to state that in fact the law needs to be strengthened, and that in fact its own research had made it clear that instead of the law being implemented properly, women were very hesitant to come forth and file under the law, as they feared that no action would take place. And they also pointed out that the police were less than efficient and they were gender biased when it came to filing cases under this law. Through the years, the other campaign that AIDWA has been involved in was for change of substantive and procedural laws relating to rape and sexual assault, and for the implementation of these laws. The mode and method of struggle has varied over all these years and has ranged from holding of protests and demonstrations to petitioning the government and other statutory bodies like the National Commission for Women or institutions like the Law Commission of India with a proposed draft of the law in the 90s. AIDWA has held meetings with and submitted memorandum to various law and home ministers on this issue. It has held and participated in innumerable discussions and seminars, workshops with other constituents of the women's movement. Through the years, AIDWA has not only demanded action when gruesome cases have come to public limelight, but has also made relentless and often on its own carried forth a campaign for better sexual assault laws and for a better criminal justice system. The movement for change of the laws of rape started after the Mathura case in the early 80s. The first phase of the movement was preoccupied with aggravated custodial forms of rape, like rape of a woman in a police station, and seeking to more harshly punish those like the police and others in positions of power who had committed the rape crime. It looked at the vulnerability of the victim of rape, who was not believed when she reported sexual assault, and sought to make changes in the law of evidence to stop judges looking at the past sexual history of the survivor to discredit her. It also asked for shifting of the burden of proof when the fact of intercourse was proved and the woman said she had not consented to custodial situations. AIDWA took part in protests, including outside the Supreme Court, and submitted a detailed memorandum to the government detailing the changes. The second phase of the movement in the early 90s started when AIDWA, along with others, submitted a draft for a new law of sexual assault to the National Commission of Women in 1993. This proposal expanded the whole definition of sexual assault to not only include the traditional notion of rape by penetration of the penis into the vagina, but also other forms of penetrative and non-penetrative sexual assault and a range of other issues. AIDWA struggled for these amendments till 2013, when the law was changed to finally incorporate provisions for stalking, disrobing, sexual harassment, voyeurism, also in the aftermath of the Nirbhaya case and the Justice Verma Committee report, and still continues to be preoccupied in its day-to-day activities. In fact, a series of seminars, talks, as I said earlier, will have to be held on each issue that AIDWA has taken up alone or together with constituents of the other women's organization and groups since the 80s and 90s. AIDWA participated in amendments to the Sati Act, including the recognition of glorification of Sati, and filed a PIL in the Supreme Court to stop the Chundri ceremony at Deurala, and got an order for deposit of all funds collected into a nationalized bank. AIDWA was also active in the formation of the statute for the National Commission for Women. Currently, however, we are passing through a dark age or dark period in which many of our rights promised in the preamble and in the fundamental rights chapter of the Indian Constitution are not being upheld by the state, including the judiciary and the police. Rights which form the bedrock of our democracy have been shrinking, and the right to freedom of speech, to protest, and to hold demonstrations are being curbed. AIDWA's struggle has therefore necessarily widened to include basic democratic rights of citizens. If speech is targeted, no other fundamental right can be asked for or remains. In a recent statement, AIDWA condemned repressive measures by the Modi government to stifle voices of dissent in our country. It demanded the release of students and activists in jail. As you know, intellectual, academics, journalists, civil rights activists, lawyers, and political opponents who oppose the present government, its policies and actions are under constant threat of backlash for their views. Women are being targeted and arrested without proper legal and constitutional procedures being followed. Some of these women have been in the news recently, and you all know about Disha Ravi and Nodeep Kaur's case, apart from Devangana, Kalita, and Natasha Narwal, Gulfisha Fatima, Israt Jahan, and Safura Zagar, who only got bail because the state agreed that it was on humanitarian basis that bail should be granted to Safura. Because any dissent against the state is termed as anti-national and unpatriotic. You will be astonished to know that the reported figures from the NCRB show that 93 sedition cases were filed in 2019, and they continue to grow. This was a 165% quantum jump from 35 cases in 2016. The sedition law is being misused to stifle the constitutional and democratic right of freedom of speech and expression, in spite of clear guidelines from the Supreme Court in Kedarnath and Balwant Singh's case. In the Kedarnath, the Supreme Court had held that mere speech without inciting violence would not amount to sedition. In the Balwant Singh case, as you will recall, though there were slogans like Khalistan Zindabad and Raj Karega Khalsa in the main market in Chandigarh, the Supreme Court held that this would not amount to sedition. These cases are not followed either in letter or spirit. However, it is perhaps worthwhile to mention that many of these sedition cases will eventually be dismissed by courts, and the rate of conviction in these cases is abysmally low, about 3%. But this is no comfort to those who have been incarcerated and tortured in jails of our country for a long time. Sedition was a law brought in by the British to silence voices of dissent, and it is time that it should go in democratic India. Sedition is described very widely as words spoken or written or visible representation by which anyone attempts to bring into contempt or incites or attempts to excite dissatisfaction towards the government, and as a punishment of life, of imprisonment with life, or 3 years. So this is a law which, though it has been uh, read down by the Supreme Court, uh, is actually a law which shouldn't exist on our statute. Another draconian law, as you all know, is the UAPA. This law has a very wide definition of a terrorist act and defines terrorism as any act with the intent to threaten which is or likely to threaten the unity, integrity, security, economic security, or sovereignty of India, or with the intent to strike terror or likely to strike terror in the people or any section of the people in India or any foreign country. Recently, bail was denied by the Session Court in the UAPA case against Natasha Narwal on the grounds of police statements, including confessions of co-accused, which are not even considered admissible in evidence. It must be noted that another court, while granting bail to Natasha uh, about the same incident, though in a different case, said that the videos of the Delhi police do not show that Natasha had been indulging in or instigating violence. Denial of bail is commonplace under UAPA, where the accused are kept locked up as under trials for years, as the UAPA law specifically denies an accused person bail if the court believes that, based on the evidence so far, the accusations against him or her are prima facie true. In the 2019, these conditions were made stronger by the Vatali case in the Supreme Court, which held that in UAPA, bail is an exception and there is no requirement of elaborate examination or dissection of the material provided by the prosecution to oppose bail and establish a prima facie case in the UAPA. Another law that is being used is the National Securities Act. The act is a preventive detention law which allows the police to arrest persons for a period of 3 months on mere suspicion that they are likely to cause disturbance in peace and harmony of an area. In December 2019, you will recall that Dr. Kafil Khan was arrested by the UP government for allegedly making inflammatory speech at the Aligarh Muslim University campus. After months of languishing in jail, the Allahabad High Court finally squashed the detention order and held that Kafil Khan had in fact given a speech calling for national integrity and unity and deprecating violence, and he had not acted in a manner prejudicial to public order as required under the Act. So, any reason, good, bad, or ugly, is enough to send somebody to jail under any of these draconian laws. And the courts are very willing to give remands, particularly at the magistrates level. They routinely put people in police custody and do not follow their constitutional duty, as recently stated by ex Justice Deepak Gupta of the Supreme Court, to read and examine the case file, including the case diary, properly. This recently happened in the Toolkit case, where Disha Ravi was remanded in police custody in Delhi without any application of mind, and even though the transit remand had not been obtained by the police to bring her from Bangalore to Delhi, though there is some questions about whether it was necessary. One of the most brutal attacks on dissenting citizens came when the government introduced amendments to the Citizenship Act, and these were widely criticized. For the first time post independence, these amendments discriminated against Muslims and proposed that only Hindus and others, excluding specifically Muslims from neighboring countries like uh, Afghanistan, Pakistan, Bangladesh, could become citizens by naturalization. Together with the amendment, the government also stated that it would draw up a national register of citizens and a national population register, which many felt would exclude Muslims and other vulnerable sections in the country who had been living in the country for decades. Women in protest came out in large numbers, as we all know, and mostly women led sit-in protest sites mushroomed in different parts of the country, with anti-CAA protests becoming the largest protests that India had witnessed post-independence. The protests were supported and included not only by Muslims but other progressive people from the left, liberals and activists and other students, etc. This irked the government, which started a counter campaign of hate speech against the protesters and naming them anti national and terrorists. In the third week of February 2020, spokespersons of the government and the ruling party, like Kapil Mishra, openly threatened the protesters and unleashed a planned program in Delhi dominated Muslim area of northeast uh, Delhi. 23rd of February onwards, mobs attacked northeast Delhi, targeting Muslim citizens and shouting Hindu nationalist slogans. Muslims overwhelmingly bore the brunt of the so-called riots, and 53 Muslims got killed, out of which 53 persons got killed, out of which 40 were Muslims. Houses, shops, and small factories were burnt and looted. Apart from those killed, hundreds were grievously injured. After the CAA protests, India witnessed perhaps an even larger struggle, which is the ongoing historic farmer struggle in which activists have been again arrested, namely Nodeep Kaur, Shiv Kumar, and even journalists like Mandeep Punya. In fact, journalists reporting on struggles and bringing alternative facts to light have been an increasing target for arrest. Journalists like Siddiqui Kapan, who was on his way to Hathras to investigate the gang rape of a Dalit girl, has been arrested and denied bail, except for 4 days. Comedians like Munawar Farooqi have been arrested on the mere whim of a state for playing a popular song. Some recent judgments, there have been some bails. Disha Ravi is on bail, uh, and Dharmendra Rana, the sessions judge who gave her bail, held that even in a conspiracy case, active participation in violence must be proved. That judge also held that editing a document did not amount to any offense. He further said that no act can be termed seditious without evidence connecting it to violence or public disorder, and that the right to dissent was guaranteed under Article 19 of the Constitution, suggesting that the founding fathers of the country accorded due respect to the divergence of opinion. It is a pity that in our country, an 83-year-old activist who was arrested under the Bhima Koregaon case was finally released on bail after for 6 months after he had been extremely unwell. His lawyer has rightfully described that this punishment of putting him in prison in this condition was cruel and inhuman. Many of our judges in the past have commented that our criminal law contemplates that bail must be the rule and jail the exception. However, this is not being followed. Nodeep Kaur, after being released from bail, related how she had been tortured. She related how Shiv Kumar, the other person who had, her associate who had been uh, also put in jail and arrested, was subject to extreme torture, and his nails were pulled out by the police. The police obviously inflicts this torture to extract confessions so that they can make a case where even none exists. In this, they are supported by their higher ups and therefore can act with impunity. However, the law speaks quite differently on this aspect. Torture is prohibited, is obviously prohibited by law, which very clearly states that even prisoners have a right to be treated in a humane manner and without violence being inflicted on them. This is part of the fair procedure, which is supposed to be guaranteed under Article 21 of the Constitution of India, is held in the Sheila Barse case, in the Bhagalpur blinding case. The Supreme Court held that torture makes a mockery of our Constitution of Article 21. In fact, in D.K. Basu's case, as early as in 1996, the court laid down several guidelines for ensuring the right of detainees in D.K. Basu was followed by changes in the criminal procedure code, outlining the rights of an accused person to inform his family of his arrest, to get a lawyer, to be medically examined, etc. In fact, Article 22 of our Constitution states that no person who is arrested can be arrested without of the grounds of his arrest, and he is entitled to his own lawyer and has to be produced in front of a magistrate within 24 hours. However, this is not done, and we all know this. And what is the solution? I think we have a long way to go as far as the law around torture is concerned. Torture has to be made directly punishable under our law, and India has to be uh, forced to sign and ratify the UN Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. The Constitution of India guarantees the freedom of speech under Article 19. The right to dissent and protest is an essential component of any democratic country. The Supreme Court, in a number of decisions, has upheld this right. Since the 70s, in the 1970, in the Mazdoor Kisan Shakti Sangatna case, the Supreme Court held that the right to protest is an integral part of democracy, and holding peaceful demonstrations by citizens to air their grievances is a fundamental right under Article 19(1)(a) and 19(1)(b) of the Constitution of India. While 19(1)(a) confers the right to free speech, 19(1)(b) gives the right to assemble peacefully and without arms. The court in this case held that the fundamental aspects of this right is to be to dissent against any action or decision by government, and that this right included the right to and to hold meetings. The Himmatlal case in the Supreme Court in 1932 held that courts can only impose restrictions on this right in the interest of public order, not by law abridge or take away right of assembly by prohibiting assembly on every public street or every public place. It clarified that the state can only make regulation in aid of the right of assembly of each citizen and can only impose reasonable restrictions in the interest of public order. In recent judgments, however, our courts have narrowed down the freedom. In the Shah democratization is not tolerated as constitutional, but must be maintained because it is indispensable. The Supreme Court actually held that public spaces cannot be occupied by protesters, and that too indefinitely. They further said that though democracy and dissent go hand in hand, the demonstrations expressing dissent have to be in a designated place. AIDWA has to face this current challenge to go forward. Some of the observations of the Supreme Court on the concept of justice and women's rights have recently come under criticism. The court has, apart from the fact that people have questioned why there is an unaccountable delay in hearings in vital cases, like those challenging the CAA, the abrogation of Article 370, and the case relating to electoral bonds. After holding that adultery is an offense and is violative of the Constitution and of Article 14 and 21, the Supreme Court has inexplicably issued notice on a petition asking for adultery to be reinstated as far as army personnel are concerned on a host of irrelevant and patriarchal grounds. During the hearing of cases relating to the ongoing farmers' agitation, the Supreme Court asked a question: why is it that women and old men are being allowed to protest, showing its lack of understanding that women have an equal stake in the struggle as they are equal partners with men in agricultural activities, apart from doing various additional jobs like gathering fodder and feeding the cattle, fetching water from tube wells, milking, cooking, etc. Thus, women have an equal or as much equal or more than equal right to be present as men to protest. In issuing notice on the draconian, completely unconstitutional law supposedly targeting love jihad, the UP Uttar Pradesh Prohibition of Unlawful Conversion of Religion Ordinance 2020, the Supreme Court, in which this law is under challenge, refused to stay the operation of the law, under which approximately till January 16th has reported 54 people have been jailed and 91 persons have been detained. Recently, the Supreme Court asked a man accused of raping a woman if he was willing to marry the girl he had raped, and if there could ever be a marital rape, even if a man was brutal in another case. In a press release, women's organizations reacted to it. Our patron, Brinda Karat, immediately wrote to the Chief Justice of India detailing why this was objectionable, and AIDWA, in a press release, pointed out that many trial court judges, instead of proceeding with the rape case according to law, asked the rapist to marry the victim. In this particular case, the girl is alleged to have been raped 10, 12 times while she was a minor. The rapist is alleged to have threatened and intimidated the girl not to report his acts. Reports have also stated that he had tied down and gagged the girl on occasions and even threatened to inflict burns on her by throwing acid. The girl apparently tried to commit suicide after these actions of the rapist. The petitioner and his family also forced the girl's mother to execute in writing that the petitioner and the victim had an affair, and they both had indulged in sex with the girl's consent. The Aurangabad High Bench of the Bombay High Court had rightly termed the law court's giving of bail to the accused atrocious and dismissed his application for bail. The Supreme Court gave a month's time to the alleged rapist for filing a regular bail application. It was also reported, and this was criticized by girls had not taken any action for And the girl, however, the girl minimized by an offer of marriage, as an offer of marriage only minimizes the violence and trauma that is by the girl or the woman during rape. In our society, there are people who think that rape brings shame and ignominy to a girl and feel that her honor can be saved if she is married to the rapist. Such thinking is extremely regressive and patriarchal, Edward pointed out, and it does not take into account the situation of the woman or the girl who has undergone this violent act. To marry her in these cases would inflict further violence on her and to further violate her. On the question of whether rape would ever occur during marriage, AIDWA pointed out in its press release that for decades women's organizations had been asking for marriage to be under uh, and for deletion. Yes, sexual and other violence is unacceptable in any society, and our law partially has recognized this by introduction of Section 498A in the IPC as far back as 1983 and in the Domestic Violence Act. It has stated that conservative and patriarchal issues that exist in sections of the Indian criminal justice system need to be weeded out, and for that gender sensitization and creating awareness was a must. AIDWA had since the early 2000 been fighting against crimes and killings in the name of honor. In Haryana, it had been regularly trying to help victims and their families with the police, courts, etc. In fact, in Haryana, AIDWA had asked the government to start safe for of killing. Sorry, I think there was some interruption. AIDWA had even suggested a comprehensive law on crimes and killings of relating to honor. However, before any positive law could come about, or before comprehensive steps could be taken to act against those who commit these crimes, BJP government in 2007 curb, further curb interfaith and intercaste marriages.
Comrade, sorry, your internet connection is a little unstable. So maybe can you keep your camera off for a bit?
Can you hear me?
I can hear you fine,
okay,
but your
I will
to make it better.
Okay, fine.
Okay.
The ordinance, the UP ordinance, is a draconian measure to stop interfaith marriages by conversion. Those who are involved by putting them in jail, punishments varying from 1 to 5 years. This harsh law is against the Constitution of India and the fundamental right of its citizens to marry and live with a person of their choice, flowing from Article 21, and to convert to any religion under Article 25. The freedom to change one's religion voluntarily has been upheld even by the Supreme Court. But the law introduced by BJP Yogi Adityanath government clearly wants to deny this right to women or men who convert before marriage or after it. The law, in tune with his earlier policies, targets Muslims and is yet another example of communal law. The UP government seeks to justify this inhuman and unconstitutional law as part of their war and campaign against the so-called love jihad. This fictional and bogus campaign alleges that Muslim youth are marrying Hindu women as part of a conspiracy to convert them to Islam, as has been shown by investigative agencies, including NIA in recent cases, in court cases. No such conspiracy exists, and women who have converted have done so of their free will to decide for choice. The UP ordinance, however, seeks to stop this, and other BJP ruled states like Madhya Pradesh have followed suit. Overwhelmingly, Muslim youth and their families have been put in jail while the police investigates their cases, since the law shifts the onus of proof to the accused or presumed guilty until they exonerate themselves, unlike in normal criminal law, where you have to prove the guilt of a person accused of a crime. In one case from Muradabad, even though the girl pointed out that she had voluntarily converted and been married months before the ordinance, the police arrested her husband and other family members. The ordinance is also badly drafted and vague, and Section 3, which defines the crime, uh, targets any conversion of one person by another by use or practice of misrepresentation, force, undue influence, coercion, allurement, by which can mean giving of gift, or by any fraudulent means, but also by marriage. It targets those who abet, convince, or conspire in such conversions. So wide network of persons can presumably be punished under this section. The onus of proof has been shifted, as I said, and this helps the police to uh, arrest and go on a rampage against people who are accused under this law. Organizations like the Bajrang Dal have uh, been active and have, in fact, uh, got a large number of people arrested. Section 6 of this draconian law states that any marriage, which is by converting himself or herself before, or any marriage by converting himself or herself before or after marriage, or by converting the woman before or after marriage, can be declared null and void by the family court on a petition presented by either party. Ironically, the parents and siblings of the girl who normally oppose such marriages by choice in these cases have been allowed to institute cases under the Act. More clearly unconstitutional provision is Section 6 of the Act, which states that a person before converting shall give a declaration to the district magistrate, who will then launch an inquiry into the real intention, purpose, and cause of the conversion. One can only imagine the consequences of such an inquiry, apart from the fact that the police be cannot do not have the competence to inquire into the real intention or purpose or cause of the proposed convention. Apart from this, religious converters can also be punished if they do not give a notice to the district collector, and they can be put in jail from 1 to 5 years. The others can be put in jail for varying times, though for any offense under the main section, if a woman is converted, the accused can be put into jail for 10 years, up to 10 years, for woman or an SC or an ST person. This legislation is another example by which Muslims have been targeted and attacked. The earlier legislation, which was communal in its intent, as I said, was the Egypt law which sought to punish triple talaq. This ordinance was passed in spite of various pronouncements of the Supreme Court in the Puttuswamy case, in the Hadia judgment, uh, and in spite of division bench judgments of the Allahabad High Court, which said that the right to live with the person of his or own choice, irrespective of professed by them, is intrinsic to the right to life and personal liberty. Interference in a personal relationship would constitute a serious encroachment into the right to freedom of choice of the two individuals. However, the right to choose one's partner is a right which young people in this country will have to fight for. Just a couple of weeks back, we heard about the father who beheaded his daughter for daring to choose. And this is another challenge which is there in front of AIDWA. Article 21 is also infringed when a woman is subjected to sexual assault. The Verma Committee held this. CEDAW has also pointed out that if there is violence, a woman's rights get affected as she cannot enjoy her basic fundamental freedoms and human rights, and thus Article 21. In several rape cases, we have seen how the rule of law has been bypassed and the rights of women survivors and victims to justice have been gutted in police station, courts, hospitals, and media alike. The fairly recent cases in Kathua, Unnao, and Hathras, and earlier cases like that of Asaram and Swami Chinmayanand has shown us that in India today, those in positions of power feel that they can act with impunity and the law does not apply to them. The government, while tom-tomming its concerns for women's rights, is ready to sacrifice the basic rights of vulnerable and poor women. After the Kathua case, the Modi government introduced uh, amendments to bring in extremely harsh punishments for certain categories of rape. And against the trend in most countries, it included the penalty of death sentence for rape of a child below 12 years of age, apart from introducing 20 years to life for rape of a woman below 16 years of age, etc. Disagreeing with these harsh punishment inserted into the penal code through the 2018 amendment, women's organizations and groups, apart from expressing other moral objections, expressly pointed out that unless there is certainty in law that a rapist will be convicted, harsh punishment by itself would be mere tokenism. It pointed out that what is required in rape trials is to follow the procedure established by law, which would mean better investigation by the police, following SOPs prescribed for cases of rape, and ensuring a better infrastructure, for example, by increasing the number of forensic laboratories to ensure that evidence was properly analyzed in a timely manner. The recent Hathras case highlights how these procedures are often deliberately not carried out. In the Hathras case, the connivance of the police and the administration of UP in hushing up the case and the manner in which the upper caste operates became obvious. The police did not carry out the investigation properly or in time. They did not register the FIR at the first instance. There have been several reports about how the police deliberately delayed the registration of the case while the girl lay outside in an obviously serious medical condition. During this time, she even spoke to an India Today journalist, naming the accused and saying that after doing Jabardasti with her, the accused hurt her grievously. Still, no FIR was lodged. Non registration has been of an FIR has been made uh, an offense in 2013, but very little action is taken on this section. Apart from that, the police helped the UP administration to jump to the conclusion that there was no rape because no semen was found on the body of the girl, even though there was an unforgivable delay in collecting medical evidence, and medical evidence was only collected after 10 days. And the girl, though the girl had complained about the rape earlier, the conclusion by the doctor that though force had been used on the girl, he would not, he would wait for the forensic evidence, uh, which was taken after 10 days, is surprising because one wonders what influenced the doctor to state this against all medical ethics. Samples which were sent naturally came back uh, because without any semen being found on the girl. The girl had been cleaned and washed several times. When she had been found by her mother, she had been stripped, badly injured, strangulated, and the mother had also reported that blood was flowing from her vagina. What constitutes rape is a question of law, and no doctor should have passed such an opinion. Significantly, no medical examination of the rape accused had been conducted. What is significant in this case is, however, a statement that the girl made that which clearly stated who the four accused were and stated how they had raped and strangulated her. And this should be construed as her dying declaration. The case is now being monitored by the Allahabad High Court, and the girl's family is under protection of the CRPC. This is because the Delhi High Court Women's Lawyers Forum filed a PIL in the Supreme Court. Hathras is mainly an example of what happens in several rape cases across the country. And clearly, the challenge before AIDWA is how to keep on fighting against the administration and the law and order machinery in all these cases. Thank you.
Thank you, Comrade Kirti, for this very, very enlightening, very enriching talk on the various historical struggles waged by AIDWA throughout these years, which have led to so many more rights being made available to women, so many basic rights for their equality and for their protection from violence and harassment and sexism, and all these legal battles which have been waged by AIDWA and other women and organizations have made it possible for women to stand up in courts and at other platforms and demand their rights. But as you said, so many battles still remain, especially in the present context, when the government is using all arms of the state machinery to clamp down on our rights, and particularly on women's freedom. And as we see that even in these times, in these dark times, AIDWA is strengthening its struggles and it's continuing to fight for various rights and freedoms, like you've mentioned already in your talk, against love jihad, for the right to choose one's partner, for marital rape to be criminalized, demanding justice for victims of sexual violence, for women farmers to be recognized, for women's right to work. All of these battles, all of these struggles are being waged, and all of them will have to continue in these dark times. Thank you, comrades, for joining us, and this is where we'll end our live today.
Thank you.